guess we're good to go.
Cool. So, maybe 2 minutes, we start. Paolo, cominciamo, che dici? Ok. C'era ancora gente in giro.
Oh, it's getting too crowded now.
I
You have to close the door.
15 minutes delay is the standard now, so we were supposed to start at
okay.
5:15.
Okay, so.
5:30.
Okay.
Yeah, I think we're still okay with the subsequent program, which,
Yes.
so,
There is another tool, walking tour, and then a dinner. You can sit down.
Continue the discussion then.
Okay, so thank you everybody for being here, and thank you, Lear, for having us here. It's a pleasure. We enjoyed the session so far. We also enjoyed the aperitif yesterday. It was really nice. So thank you. So here today we're discussing an issue that has been the subject of heated debates in the past and is now the subject of heated debate, and I think it will be in the future even more the subject of discussions. So it is the relationship between leniency and private damages actions. I will say something obvious. First of all, that an efficient and widely used leniency system is good for public enforcement. It has been a very important part, at least until recently. So many cases in the EU started after a leniency application. It is not so much like this now, and it has not been like this in every jurisdiction, but in most jurisdictions that was the case. We can also say that an healthy leniency system is also beneficial for private enforcement, as many private damages actions started following follow-on actions, so follow a decision by the court, the commission or whatever. The most tricky issue is what happens the other way around. So what are the effects of private damages actions on leniency? We know that in recent years there has been a decline in leniency applications, so sharp decline. We've seen some statistics just in the session before. And there has been a sharp increase in private damages actions. Many litigations are brought. Not many cases are in the end decided, but still there are many cases going on. And this is a fact. The reasons for why leniency applications are declining is an altogether different thing. And this is what we will discuss today. So whether this is due to the fact that private actions are rising or not, or whether there's no connection and the reasons are different. There are other factors. One other thing is whether and how leniency should be boosted. And I'll say whether and how. So not only how, but also whether. Or whether there are other means to improve public enforcement, so to make it greater. We know that in the past, in the context of the Green Paper that preceded the adoption of the Damages Directive, there have been some options that were considered, and one of the options was to grant the leniency applicant some sort of rebate in damages actions. And then the options was not considered, and it was left there. And we know that there have been some facilities and some helps for the leniency applicants in the damages directives, but that relates to different things. So it's only on disclosure of evidence and joint and several liability, and probably that is felt as not being enough. Then there was something inserted in the CM Plus directive, And we know that the DSM Plus provided that in the persons, so former and current directors, managers, and members of staff of a company asking for immunity can have, in some cases, can be shielded from personal liability in criminal cases. And that mostly concerns bid rigging, but not only. And probably we will see an increase in damages in leniency applications in bid rigging cases, and we've heard from the Italian commissioner that this is already the case in Italy. In Italy, we have very low leniency applications, so not many cases started after leniency, and probably this will be an area of great interest, also considering that many cases, she said 50% more or less of cases, of cartel cases, are concerned with rigging. So this is probably going to improve leniency applications in Italy, but probably this is not, again, enough. Then just recently, 2 weeks ago, speaking at a conference in Florence, Margaret Vestager talked about the subject. So she talked about whether to boost leniency, and she prompted the start of a debate on how to reform leniency systems. And still with a view to maintaining the attractiveness of leniency, but at the same time without jeopardizing and the damages actions, and obviously maintaining the damages, the right of injured parties to obtain compensation. We're going to discuss these issues and with our panelists. We have Xandra Reintjes from the Commission, and she's here connected online. And here we have Tilman Makatsch from Deutsche Bahn and Thomas Funke from Osborne Clarke. So I'll start introducing Xandra. And she's a policy officer at the European Commission, DG Competition. She works in the unit responsible for the ECN, so the European Competition Network, and policy development, and she deals particularly, among other things, also with private enforcement. And I think that she will be involved in the debate that is going to come. Then we have Tilman Makatsch, is from Deutsche Bahn. He's the head of competition litigation and antitrust economic at Deutsche Bahn, and he's also managing director at DB Competition Claims GmbH, which is a company that was created by Deutsche Bahn to bring claims for group companies and non-group companies, so joining together different claims. And under Tilman's leadership, Deutsche Bahn has been a pioneer in damages claims, and we know that they've been involved in many cases, and one of them is the trucks cartel, but that's only one. And then we have Thomas Funke. Thomas is our partner at Osborne Clarke, and he's based in Cologne and Brussels, and he's also the co-head of our international competition practice. Thomas is heavily involved in private litigation, so damages claims, and also cartel litigation, cartel enforcement, and also leniency applications, so assistance to leniency applicants. And he is currently representing Deutsche Bahn in one of the trucks cartel cases. So I think that I can leave the floor to Xandra. And
that's okay.
She's going to...
I'll start by trying to share a presentation I prepared, also to avoid having my own face this big on the screen. Just let me know if it works.
Perfect.
Yeah?
Yeah.
Perfect.
Okay, great. So yes, thank you, Valeria, for the introduction. I will try to give the perspective a bit from the Commission's point of view, although these are also personal sites. But I wanted to give you, first of all, a bit of a general overview, and then some more topics in particular. So, as you may know, there are, of course, different goals to be distinguished between public and private enforcement. Public enforcement is focused on detecting, examining, and bringing anti-competitive activity to an end, as well as imposing sanctions for infringements to punish and deter future infringements. Whereas on the other hand, private enforcement is, of course, focused on compensating those who have suffered harm as a result of an infringement. Then on the interplay between public and private enforcement, generally speaking, public and private enforcement are complementary. To a large extent, they reinforce one another, and to some extent, they also overlap, for example, in terms of clarifying the law and deterrence. So here on this slide, you can see a bit of an overview of some of the elements that illustrate this, but I didn't want to spend too much time on it. Then we have the Damages Directive, of course, since 2014. And the Damages Directive takes the interaction between public and private enforcement into account. It expresses the complementarity in the form of two main goals. And the first one is the facilitation of damages claims. And the second one is to strike the right balance for maximum effectiveness of Articles 101 and 102 of the treaty. So, as you may well know, the Damages Directive provides for common minimum standards to harmonize private damages rules in the member states. It involves rules on disclosure of evidence, the effect of enforcement decisions and limitation periods. It also establishes standing of indirect purchasers, joint liability for the infringers, and the option of consensual dispute resolution. Furthermore, some clarity is provided on how to pass on, how the pass on of overcharges may be applied, and how harm can be quantified. The right to claim damages for loss caused by infringements of Articles 101 and 102 of the treaty was first acknowledged longer ago by the Court of Justice, some 20 years ago, in the case of Courage and Crean. It's a judgment of 20 September 2001. It confirmed that Articles 101 and 102 of the treaty produce direct effects between individuals, and that actions for damages can make a significant contribution to the maintenance of effective competition. The Damages Directive codified and further built upon this and later case law. Now, as regards this first goal of facilitating damages actions or damages litigation, I think you can see here in the slide that has been achieved. This graph shows a rising trend, which started already before the Damages Directive was first introduced. However, you can also see it picked up further since then, even if the actual effects of the Damages Directive should normally only have started to kick in through implementation. So I've indicated that with the three arrows. The first one is the case of the court in Courage and Crean, and the second one is the adoption of the Damages Directive, and the third one is the actual implementation by all member states. Because in fact, the member states needed to implement the directive in their legal systems by 27 December 2016, but in practice, this only happened by the first half of 2018. Then by the end of 2020, the Commission published a report on the implementation of the Damages Directive. This was published on the 14th of December 2020, and at the time it was concluded that there was still insufficient evidence to carry out a meaningful evaluation of the Damages Directive. And the reason for that is that it can take a long time from the purchase of a product or a service that has been subject to an infringement of Articles 101 or 102 until the first judgment, and approximately 13 years according to another study by Jean-François Laborde. And the Commission nevertheless continues to monitor developments in the member states in this area with a view to carrying out an evaluation of the directive once sufficient experience from the application of the new rules has accumulated. Now, at the same time, an important element of public enforcement is, of course, the leniency tool. And here you can see two trends. First of all, a multiplication of leniency programs adopted by an increasing number of countries around the world, in particular since the year 2000. And secondly, also a clear downward trend in leniency applications in more recent years, especially since 2015. So the second downward trend in leniency applications is also global. So it includes jurisdictions where the right to claim damages for antitrust infringements was already more common. So even before the case of Courage and Korean and the Damages Directive. Now, the question is, of course, what causal relationships can be found as regards the downward trend in leniency applications, and to what extent this is affected by the rise in private enforcement. As also announced by our commissioner, the Executive Vice President Vestager, an exercise on the reasons behind is ongoing internally at the Commission. So we have engaged both with the private bar and other authorities, and there appears to be a number of possible factors, but not one of them in particular. I will touch upon three main ones, that seem to be main ones at least. So first of all, there is the risk of follow-on damages cases, which may, of course, involve high amounts of damages and long-term uncertainty on the outcomes. The Damages Directive does provide some protection already, which is built in, so the immunity recipient is only primarily liable vis-à-vis its own customers, and another protection is, of course, the protection of corporate statements from disclosure. Then a second factor is the huge proliferation of competition regimes, including leniency programs throughout the world. And I think that you could very clearly see on the slide I showed earlier, where you could see that this is really significant since the year 2000. A problem may be that these programs are not always similar, or they may even be contradictory at times. So addressing this will require involvement in many jurisdictions, possibly through ICN as well. And then a third factor that we've seen is the change in types of cartels, which may be more atypical, and this may make it more difficult to come forward, as companies and their advisors may not be certain whether the specific behavior fits the definition of a cartel. Examples you could think of are, for example, the benchmark manipulations that we've seen, so in the yen interest rate derivatives and the IRT cases. Another type of case is a restriction of innovation, as we've seen in car emissions. And yet another one is types of information exchanges. We have the bananas case, but there's also a more recent case of Insurance Ireland. So these are some three main factors that we've seen, but as I said, there is not one in particular, and they're also not the only ones. The importance of continued strong enforcement activity is obvious. In 2021, the Commission has adopted 10 cartel decisions and imposed a total of 1.7 billion in fines. So this is something the Commission is clearly focusing on. And furthermore, the Commission will look into possible short-term and longer-term steps. As also mentioned by Commissioner Vestager, this may involve the collection of further information, including through the use of more data analytics, as well as increasing transparency as regards what could qualify as for leniency or as a cartel, and how the leniency program works. And then when the time is ripe, the Commission may further consider the functioning of the Damages Directive. So I'll leave it at that for now.
Thank you, Xandra. That was very interesting. Then I'll leave the floor to Tilman.
Okay, thank you, Xandra, and I totally agree that the Damages Directive is a success, and in particular with regard to the quantity of claims, probably not with regard to the compensation, because I mean, at least in Germany, we see rarely any judgments awarding compensation yet. So probably this is also one thing the private enforcement unit could think about, but because in the end it's all about will I get compensated or not. The massive decline in leniency applications is well known and is a global trend, and I think it's also important. It's a trend not only in the EU and not a trend only where the Damages Directive is transformed into international law. It's a general trend. And one could ask why this is the case. And in Germany, the president of the Federal Cartel Office knows perfectly well why this is the case. And he suggested to grant immunity for the leniency applicant, not only or for the leniency recipient, not only for the fines, but also from damages. And the German Monopoly Commission suggested already a wording, so it works. They work close very well together, and it only has to be transformed into EU law, which should be the next step within days, probably. But if we just go one step back, and I mean, just surprisingly, if the leniency applications won't go up again after our president succeeded in his, we have to think about probably a bit more deeper into the whole system, and we have to bear in mind, and this is completely right, that we have already privileges for the leniency recipient, joint and several liability on disclosure, the blacklist. So in the end, it's somehow more a religious approach, right? Do you believe that there are less cartels, or do you believe the leniency programs are less attractive? And to my knowledge, nobody knows. Or do you need other means to detect cartels? For the first option, less cartels, you can raise some arguments and say, okay, we have a strong, successful public enforcement, and you just named it, Xandra, with regard to cases and to fines. There's no decline yet. We have a really strong private enforcement. We have competition law compliance, which takes up in the last 10 years. So one could say that this has a deterrent effect, at least on hardcore cartels. On the other hand side, you hear from the market, especially from the cartelist industry lawyers, that there are a lot of leniency applications out there just under the desks, so that they can be presented once a cartel authority starts an investigation, at least to be the second or the third. That's what we hear if you listen carefully in the market. And you could ask yourself, why is this the case? Why? I mean, if they have an internal investigation and have a leniency application already, why don't they file it? And probably this is a question of attractiveness, and there are still certain uncertainties even after the ECN Plus directive with regard to the cartel concept, with the jurisdiction, lack of a at least global one-stop shop, high administrative hurdles, high costs, discretionary marker system. We have the problem of criminal sanctions, yet in Germany at least, also for bid rigging. And you have the private enforcement, of course, in the end. So we are in the middle of uncertainty of religion, nobody knows. But in this, on this level, I think it's really difficult to change the directive to the detriment of the cartel victims. And I have some doubts whether this is This really helps in the end. I see a violation of the right to full compensation if you cannot choose where do you want to be, from whom do you want to be compensated. For example, if you just have a business relationship to the leniency applicant. I think the topic of default liability in the case of the inability to compensate for the leniency applicant is a huge problem. As we know, those cases take ages. They take 10 years and longer, and you live in this area of uncertainty. One big problem could be that we won't see any out-of-court solutions and settlements, because no cartelists ever want to compensate for damages for others, for the leniency applicant. Why should he? So you will see any case coming before court, and at least in Germany, the civil court are overloaded yet, and it's really hard for them. One last but not least important point is that if you know that the leniency applicant is free and will never have any risk of paying anything, civil and fines, then the reliability of evidence could be different. And what about the second and third? Will they ever file for leniency? If they know they have to bear the risks for the first, so probably important evidence will get lost. And it could be also that this has a detrimental effect on the market structure, because normally the first is the big company, has a huge competition law unit, in-house competition law unit, and they file for leniency, and the second, third could be smaller entities, and now they have to even not only pay the fines but also the damages for the first. So having said that, I think, and we've heard this noon or this morning that some cartel authorities are getting bored, and they're complaining because there are no leniency applications coming in. So I would suggest to do something completely crazy and to invest in detection and strengthening the detection tools, and probably to try to find cartels. I mean, this is their main core. So we've heard that cartel screening tools is important, and I think in the area of big data, in machine learning and algorithms, you can make use of it. And there are certain ways of doing this, and I've heard that at the EU Commission, at least, there are some data analysts looking at this. We see it in the CMA and the DOJ, and we should watch closely whether national authorities also invest in this. We have, of course, the whistleblowing. We have ex officio investigations. So we have other means before doing something we probably would regret when we amend the directive to the detriment of the cartel victim. Thank you.
Thank you, Tilman. Definitely it was loud and clear, the message. And Thomas, what can you tell us about in these areas?
Well, if this is a question of religion, then I think we've come to the right place. Thank you, Valeria. I agree with almost everything that Xandra and Tilman have said. There are indeed a number of factors to be considered. And our host, Paolo, has written on the subject. And I would also like to point to the excellent paper that Tilman Makatsch has recently published on the same issue, and we have a machine translation into English available on that. And for those of you who are looking for more background materials, there is a study from the United States from Judges Ginsburg and Cheng, which also point to the possibility of there being a number of factors that are relevant, as indeed the Damages Actions Directive is a European phenomenon, but also elsewhere in the world do we see a change in the number of leniency applications. So I'd like to make 5 points from my experience in private practice. The first is that if you want leniency to be attractive, then those in charge of designing the leniency programs can probably do their part of the job. Leniency is not perfect yet. It requires a lot of effort. You have requirements to fulfill. We've just heard 63 different leniency regimes in the world. And the need to satisfy the authorities' appetite for data, often in local language, to ensure the cooperation of each and every employee, that's very burdensome. I'm fully aware that even a leniency applicant is a co-conspirator, so I'm not asking for the red carpet to be rolled out. But when it comes to one competition authority requiring that the participation in the anti-competitive conduct be continued until they are ready to conduct the dawn raid, whereas others require the same leniency applicant to stop the conduct immediately, otherwise they risk losing the benefit of the leniency status, or at least the privilege of being first in line, then that's cumbersome and that's difficult. We know there is a lot of cooperation, and in practice it often works, but convincing a CEO to rely on the promise of an authority to work it out with their international counterparts is not easy. So, and it's certainly not easier either when you've got the responsibility of individuals involved as well. So they can use some certainty as well. We know the British concept even provides for a reward for those who blow the whistle, something to be considered. My second point, the statistics require a closer look. From the head of the Austrian authority, I heard that their number of leniency applications is not in decline, but actually going up. There is a recent OECD report which benchmarks the number of leniency applications in a similar way that we've just seen as on Xandra's slides, by taking at a benchmark the years when the number of leniency applications were at an all-time high. Some of us might remember the days of the auto parts cartels, which were one reason for an unprecedented rise. Applications were fewer before, and they have been fewer since. Why? Well, on the one hand, the risk of detection was lower in recent years. There were no dawn raids during COVID, and companies knew this. And besides, many authorities are so busy going after the digital platforms that they are strained for resource for doing anything else. And then secondly, I think we can congratulate ourselves. I think all of us have played a part in bringing the number of applications down, because we have reasons to suspicion that the number of cartels might be going down. If they weren't, most of us wouldn't have a right to be here in Rome and enjoy this wonderful conference, but we should probably be looking for different jobs if none of what we do, public enforcement, private enforcement, compliance efforts, if none of that had any effect. In that case, we would need a different system, maybe with criminal sanctions. I'm slightly optimistic there, but again, open to debate. Third point, yes, the number of damages actions has gone up, but the Laborde study really requires a closer look. I love Jean-François Laborde, we've contributed to the study, but if you look at the way he looks at the number of Spanish judgments and interim judgments and which French decisions he factors in, it's a bit complicated. From my experience, Valeria mentioned my work for Deutsche Bahn. I've also litigated against the hydrogen peroxide cartel and beer and sugar and coffee roasters. So yes, more companies are willing to assert their claims, and they have a right to compensation. That's a fundamental right to be compensated, but it's still a very cumbersome and costly exercise. And now litigation funding is even under political pressure from the European Parliament. So we don't live in a world where the rise in the number of registered cases would equal the economic pressure that it might indicate. So I think also for settlement discussions, it is important for litigation to be a credible alternative to negotiated agreement. My fourth point, leniency is not an end in itself. It is a means to achieve an ends, and maybe there are other, more modern means to achieve the same ends. We heard from Joe Harrington about cartel detection, and Tilman's company has come up with a software product to this end, and there is a lot of research going on in this space. I still think leniency is going to be good and important for the future, but there was a time before leniency being the perfect tool, and maybe it will need to be complemented. Fifth and finally, the deterrent effect of public enforcement is complemented by the deterrent effect of private enforcement. The European Court of Justice has clearly stated that there is a public interest in private enforcement, which is why the type of finger pointing that we've seen from some national enforcers seems a bit unfair. It reminds me of my sons sometimes fighting among themselves or being jealous, and I remind them that they are brothers. So two sides to the same coin, siblings, and if a choice had to be made, then I think the monies from the cartelist should rather go to those adversely affected by the cartel rather than to government. Ultimately, the right to private redress is rooted in EU primary law, so no regulation, no directive could seem to limit it, especially when redress is not available from any other member of the cartel, so effective redress must still be possible, and if there is no one available, then I think there would need to be some liability of the leniency recipient as well. That's my 5 points in 5 minutes or so.
Thank you. Thank you, Thomas. All very interesting. And now, I mean, unless people from the audience have got questions, I think I have to, okay, you do.
So if due to internal investigations and compliance, the companies decided to stop the cartel and to end the cartel, this.
Their own participation, but what about the others? Because then the others would know before we come out with leniency. We cannot stop cartel.
But this is also what I've heard, that some lawyers are busy just to end cartels. So they do the work of the cartel offices without a fine and without fines and without damages. Yeah. Well, and probably one thing I have to add, I believe in whistleblowing as well, and I think it can be really effective, and what I've heard from the Austrian authorities, it led to some serious investigations, and for example, I mean, you can incentivize this, for example, I think in the UK, the CMA pays up to £200,000 and grant immunity, and also criminal immunity for whistleblowing. So this is something one could think about as well.
I want to try with all the microphone. Okay, sorry.
Yeah, I just want to get an observation, maybe we can chat it out later, which is that if I think about private enforcement in the U.S., probably the most important role is not in the following cases, the cases that are not pursued by the Department of Justice. And there's a lot of private litigation like that. And these are also lobbying practices which wouldn't easily fall into the Leniency program. They're not the kind of explicit solution. And so those types of cases are almost exclusively pursued by private litigants. And so I think that is as important, really, as the fact that the additional penalties that come from, following that system. And so I'll just leave that as more of a question later, which is, what would it take for this to occur in the EU, that is, private litigants bring cases that are not brought by public prosecutors?
Discovery.
Uh,
I mean, I think the discovery rules in the US mean that as a private litigant, you get access to enough evidence that you will never have actually as an individual, which is why also going, I mean, at least that's.
But- Yeah, but isn't it that in the US you only have criminal immunity if you compensate your business partners?
Well, these would be civil cases.
So you have to settle before getting the fine bill, or I think this could be some interesting aspect in putting the private and the public enforcement a bit more close together. And I've understood that in the US this is somehow the case.
But one advantage you have in the US is treble damages. So I think in terms of risk return to litigate privately, it's more interesting, and you have confused fees. So I think class action law firms can say, well, let's do it. If we have reliable data, we find an expert, we could do it, because then we know that the upside is really significant.
if I may, I think that could be interesting for us. We don't need a funder. We have a team of 8 colleagues dealing with that. 2 of them are economists, and what we do is when we have our cartel screening tool developed and established in the beginning of this year, and we saw in 2 cases we saw some weird movements going on, and we looked at it in depth, and we will bring them to the attention of the German authority later this year and see what's happening. I can understand if an entity doesn't have the resources, then it could be the case. So what is the authority doing now? What they used to do is, I think what we've heard this noon is, they said, well, look, I don't have any resources as well because I have a lot of leniency applications there, but now this is gone, and they probably have some resources to look at it. And I don't know. I will see, and we will see, and if this is an area for litigation funders, why not? An alternative could be not to bring this to the attention of the authorities at all. Just to approach your business partners and say, well, look, there's something wrong. I mean, you can either compensate or, but this is, I think, not in public interest as far as I understood.
And I think to your point, like with the authorities, because you're relying on the doorway powers to gather evidence. Because without discovery, you actually have a private benefit. You have no manner of getting evidence from the other party of what they've been doing. And I think for me, this is one of the main aspects.
I think for Xandra's benefit, let's use the microphone.
It works?
Yeah,
sorry, I was just saying the reason. Yeah, I was saying the reason normally, at least in Europe, you would go to the authorities is because they have the powers with Dawn Raid to gather all the evidence that you need, which has a private party without discovery rules, American style, you cannot do. So you have a claim, you have a suspicion. I think, as you know, just quoting roughly earlier, the economists can show there was a crime, but they can't show who the criminal is. So this is the situation where you can see there's something weird happening with your partners, with the pricing, with closing, whatever, but you have no way of gathering any evidence in support.
I was just wondering, Thomas, we spoke the other day about immunity programs and this idea that Andreas Mundt has been pushing for extending the notion of immunity to corporates. Do you see any kind of progress in the development of that idea? This is a question for the panel, really. And what do you think might be the next sort of development on that idea?
Well, Andreas's idea has translated into a proposal that the Monopolies Commission included in their recent report, and that proposal is currently out there for feedback from stakeholders. So anybody who wants to comment will still have until the end of this month to feedback their ideas to the German Ministry of Economics. So in essence, that proposal provides for an exemption from civil liability of a leniency recipient, except where that company is dominant and except where there is no other member of the cartel that the injured party can receive compensation from. I'm cutting it a bit short here, but in essence that is what that proposal is about. Now I'm wondering, since this is a subject area already addressed in great detail in the Damages Directive, whether a single member state can go chevalier seul, or whether this is something that only the EU can legislate on. Interestingly, earlier this week, Germany came up with a legislative proposal for a reform of our Competition Act, and the Monopolies Commission's proposal to limit the civil liability of the leniency recipient is not in that. So it's entirely possible that they just want to push Brussels forward. I don't know. But the proposal is out there, and there are other proposals from academics, Christian Kersting notably, which have been around for a number of years, and I wouldn't be surprised if something were to happen.
Yeah, maybe I can just briefly respond to that. I don't have the answers, but I mean, there are clear legal questions to be considered. And as I also tried to show, it's of course a balance to be struck, and changing certain elements doesn't mean that it doesn't have an impact on others. Especially the right to full compensation is of course very important. That's established by law. But other things that are to be considered are also incentives for other cartel participants and potential effects on market structure. And I see that this has been mentioned by saying that it should not be the dominant player, or that other compensation, if compensation by the others is not possible, then there should be a sort of secondary liability. But yeah, these are not straightforward solutions, or they're not straightforward answers to be given to that. And from the procedural perspective, of course, there is a path that has to be followed of an evaluation and evidence-based solutions, and that takes time. So, and then there is, on top of that, the fact that retroactive effect on substance will be excluded. So the actual moment when any potential changes of the Damages Directive might kick in is really a long-term solution. So that's, yeah, just to add that nuance to the debate here.
Is there something, just a short question, sorry. Is the Commission trying to investigate into this issue a bit further? We've heard that there are economic studies, but they are not robust enough to base any decision on that. So is this something you look at, and you probably try to get other studies, or do you just collect more data and wait a little bit what kind of developments are going to come?
Yeah, well, as I said, I cannot be very concrete here, but as I said, that the exercise internally is going on to understand better the reasons behind, and to gain more information, including through data. So that is, yeah, it's work in progress.
Okay.
Can I make a remark? First, I have a question. Is the immunity from civil liability just for the first leniency applicant, or for all leniency recipients? The one envisaged in the proposed law in Germany, for the first one?
Yes, indeed, just for the first, for the recipient of full immunity. So the question of how this is going to affect the readiness of those who might come in second or third is an interesting one. But then between different jurisdictions, you have different procedural rules as to whether a potential applicant will learn whether the number one spot is still available or not. That too is something that could be harmonized potentially.
No, my remark is that we have to understand and to be clear about the purpose of the leniency program. Is that to uncover cartels, or to deter cartels? And I believe that deterrence should be the primary goal of any piece of legislation concerning cartels. Now, all the concerns that I've heard today about extending the immunity on civil liability to the first leniency applicant are about the ability of uncover cartels, or to compensate the victim of cartels, even though I do not really believe that those concerns are well grounded. I don't see, for instance, why the victim of a cartel wants to be compensated by one specific cartel list when compensation is, sum of money. So whether that sum of money comes from a certain cartel list or another one doesn't make any difference in my view. So I don't see this as a big problem. But in terms of deterrence, this, you also mentioned the market structure. Market structure, the concern here is that the first leniency applicant may get, a competitive advantage. Well, that's fantastic from the deterrence point of view because, there will be no trust among cartelists since they know that, one of them can take advantage of the situation of the legislation and become dominant in the market. So the cartel will fall apart and probably will never start. So from the deterrence point of view, this might be very effective, and this is the best way to compensate the victim of cartels because they do not become victims of cartels in the first place. So this is an important point, and from a social welfare point of view, deterrence is really the thing that matters, and we should not forget this.
May I just add one comment to your comment? Because, I mean, it's perfectly clear, and I understand, and I think the basis for that is if you have, for example, 4 participants in the market and they all have more or less the same market share and the same size and the same turnover, that's fine. But the world is different, and that's why I think it's important also for the victim to know where to get compensated, because normally you have one very big supplier, you have one who's insolvent, you have one who's close to insolvency, and you have one very small. So you know from the beginning that you will never ever get compensated without the leniency applicant. But this regulation forces you to litigate for 10 years. And in this uncertainty, and then you even have to try to get the money after you get your judgment, your final judgment. And in this way of uncertainty, it's uncertain for everybody, including the first leniency applicant, because he doesn't know whether in the end he has to pay it.
But do you believe that, let's talk about the truck cartels. Do you believe that without Daimler, we would be in a position not to get any compensation for the
No, it's not about Daimler, but we see it, for example, in tracks, in rail tracks. Yeah, we saw there's a very tight market, and there was just one left out of 4, or 2 left.
Yeah,
there was just 2 left, and one was close to insolvency. So, don't you want to have the choice?
Yeah, in that case, you can say you risk not being compensated if the first leniency applicant get away with it, right? But that's a very specific and special circumstance, and indeed, as far as I understand, the German proposal is to keep the leniency, the immunity recipient as, the subject is liable for compensating damages if all the others cannot do that. So there is sort of last resort liability, which is a way to, balance the 2 risks. I really don't think that this risk is so frequent. All right, that's a matter. That's an empirical question. It's a matter of fact. So I don't know. I do not have enough information to say so. But based on my experience, I don't see that without one specific cartel member, the others, are not able to compensate the harm caused to the victims. Especially if we make the choice that the Commission has done to prevent the claimants to get access to the information that has been provided by the leniency applicant, which strongly diminishes the ability for those victims to be compensated because they have much less information. And if there is any reason, and I don't see any reason for preventing claimants to get information provided by the leniency applicant, there are no reason whatsoever. It doesn't make any sense to prevent claimants to get information from settlement procedures. Really, I don't see. any reason for doing that. And take the truck decision. It's a settlement decision with no information whatsoever on the functioning of the cartel. And so this makes, very difficult the life of the claimant in civil proceedings.
Agreed. There was one suggestion in the German market. I stop afterwards as well. One interesting suggestion in the German market was said, okay, the leniency applicant who will be immune from public and private enforcement has to give everything that he has provided to the authority, to the cartel victim. And this could be quite interesting game changer then. And one could discuss this because so the cartel victim could use this in order to get compensated. But if in the end the leniency applicant has to pay because the others don't have enough money, and then he probably is reluctant even to file for leniency. So this has another effect then. Okay, sorry.
No, thank you all. I mean, the discussion was very, very interesting, so thank you. I think we've run out of time. But so thank you all, and I'll see you tonight.
Sorry, for the one that have booked for the
Xandra,
walking
thank
tour,
you so
the
much.
appointment is now at the info desk, and there will be a bus that pick up you to the Roman
We've got a
Forum.
pretty impressive room with pretty impressive people here, and we'll continue the discussion over dinner within this group. And please say hello to Niklas and Rainer, and I hope that we'll have a chance to see each other live and in person one of these days. Thank you so much.
Hello.
Yes, great idea. Thank you for the nice discussion and interesting view.
Thank you.
Yes.
Bye-bye.
Bye-bye.
Yeah, but we don't do